Okay, so I think it's been an extraordinary chance to dialogue with people from all over the political spectrum. I think you guys had a chance to hear a great introduction to the overview of an Article 5 convention, the pros, the cons, the procedures. And so now what we're going to do is try and hopefully provide somebody that's a little more entertaining and still has a really deep view on this subject. And so our next speaker is Glenn Reynolds. Glenn is a professor at the University of Tennessee School of Law. He's the author of numerous articles on constitutional law from a systems perspective, including Chaos in the Court, Divine Operating System, as well as extensive scholarship on the Second Amendment and various law and technology issues. He writes...
Left out is democracy like sex.
I'm sorry. Well, I'm trying not to be controversial. Democracy like sex. Does that sound like a good one? And the way that I know Glenn is from his blog. Many of you might know him as Instapundit. And it's required reading for a lot of us. And because I think a lot of us who are political junkies, we like the fact that Glenn is not just a political junkie, but he throws in all kinds of strange things about photography and the world, and just seems like the things that interest him. So without further ado, hopefully somebody very interesting to you guys as he is to the rest of us, Glenn Reynolds.
Thanks very much. It's great to be here, and I have to say, my biggest concern is that I'm too excited about this. And let me explain. First of all, there's just a matter of well, vindication's not quite the right word, but it'll do. For my sins, I spent the last several years serving as an advisor to the Law Review. And one of the things that means is that every year, the newly elected Law Review editors, before they've been beaten down and stressed out and pushed to the point of near suicide, come to your office all bright-eyed and bushy-tailed and full of excitement, and they say, what would be some great symposium ideas? And so about a year and a half ago, they did that. And I said, I think a symposium on constitutional conventions would be good. I don't know why, it just seems like that's going to be hot. So, okay. And the symposium's out. It's just appeared, actually, because you know how law reviews are. The rule is, the month on the cover is never the month in which the issue actually comes out. Or, if it is, then the year on the cover isn't the year. So, but it did finally come out, and it's got Randy Barnett and Richard Epstein and Elizabeth Price Foley and Ann Bartow and Sandy Levinson and a bunch of other people in there. And it's worth your time. In fact, some of the authors are here at this conference. So that's pretty cool. Second of all is that I'm a professor of constitutional law, and there's no bigger deal for a professor of constitutional law than if we were to get a whole new constitution. Right? Like, for me, I've been fortunate enough that I started writing about the Second Amendment in the 90s, shortly after Sandy Levinson did. And thanks to what the Supreme Court has done since, a whole extra tenth of the Bill of Rights opened up, and you could write the first articles on different subjects, and that was pretty cool. Now, we've kind of mined that out a fair amount. We've reached the point where my next piece is on Second Amendment penumbras, so you can tell where that's going. But it's pretty exciting. And so I have to ask myself, am I excited about this because I'm a constitutional law professor and a new constitution would just sort of be a fun toy to play with? Or is there more to it than that? And I think there is more to it than that. And part of the reason is relatively few of you here today are constitutional law professors, and yet you apparently are still interested in this. And there is this widespread sense that something's not quite right. Now, I'm not sure which way this cuts, but that sense isn't limited to the United States. In fact, it's actually worse in Europe. They don't have our Constitution. They have their own constitutions, or what takes the place of a constitution. Apparently those aren't working so great for them either. Which means maybe that's not the problem. And the other thing about it is that, and Larry Tribe touched on this earlier, when you talk about a constitutional convention, you can't help but think of Jefferson and Madison and all of these people who were the framers and the founders of our early republic. And we don't have those guys now. And I really do think we have, in many ways, the worst political class in our country's history. And there seems to be bipartisan agreement on that, which is good, except if you have the worst political class in your country's history and you want to have a constitutional convention, is that the same as saying we have the worst medical class in our country's history, I'm ready for my brain surgery, doctor? And I don't know. I mean, I think this is the case where this could be the cure or not. I'm really not sure. So I'm going to talk a little about this. I'm going to talk about some of my concerns. I'm going to talk about some of the arguments in favor of doing something. And I was asked to give this keynote speech from the right. And from my perspective, I'm standing on the right. From your perspective, I'm on the left. I don't really know what that means very much either, and I don't know that I'm really the best person for it. I am, philosophically, a libertarian transhumanist, which doesn't exactly, I mean, if you squint right, you can call that the right, but it's not traditionally conservative. And if I were to sort of talk about amending the Constitution from a libertarian transhumanist perspective, we'd be talking about things like personhood for artificial intelligence, equal protection for cyborgs, a right to mind uploading, all of which I'm happy to talk about at length, but you're not happy to listen. So I thought I would interpret my charge broadly and ask myself, how would a small c conservative, which in some ways I am, look at this? And because I'm a small c conservative who's also a geek, I have a quote from Neil Stephenson. Yeah, you got to applaud Neil Stephenson. He rocks. And he's got a new book out, which I don't have time to read because I'm here. So this is what he says. Intellectualism failed, and everyone knows it. In places like Russia and Germany, the common people agreed to loosen their grip on traditional folkways, mores, and religion, and let the intellectuals run with the ball. And they screwed everything up and turned the century into an abattoir. Those wordy intellectuals used to be merely tedious. Now they seem kind of dangerous as well. We Americans are the only ones who didn't get creamed at some point during all of this. We are free and prosperous because we've inherited political and value systems fabricated by a particular set of 18th century intellectuals who happen to get it right. But we have lost touch with those intellectuals. Now that's a cautionary note from Neil Stephenson, who's a really smart guy. And I think it's a worthwhile cautionary note to keep in mind as you do this sort of thing. A constitutional convention might be a cure for some of the problems he describes, actually. It might be a case of the common people getting their grip back on some of the reins of power that they've let loose into the hands of what we seem to agree in this room is the worst political class in our nation's history. But it is also a dangerous enterprise. And that's why I have to say I agree very much with Larry Tribe. In fact, because I am a geek, I have an analogy. And my analogy is to the, you know the old Asteroids video game? It's the hyperspace button. Right? You're playing asteroids, you're shooting at the rocks, they're blowing up, you get in trouble, you're doomed. What do? You hit the hyperspace button. What happens when you hit the hyperspace button? Well, most of the time you reappear somewhere else on the screen. But a pretty substantial amount of the time you don't. It's for use in extremis. An open constitutional convention, a complete redo of the Constitution, is like the hyperspace buttons. It's something to use only if you're in extremis. Now, are we in extremis? Again, I sort of have problems. On the one hand, in spite of the last couple of years of economic catastrophe and such, things aren't really that bad, you know? I mean, compare it to Europe during any of its various wars, or even the U.S. during the Civil War. To look around you right now and see people who are mostly following the law and mostly paying their taxes and, you know, mostly doing their jobs, it's not quite apocalyptic. On the other hand, there are some warning signs. And here's one. Last month, the Rasmussen poll showed that 17% of Americans believe the current government has the consent of the governed. 17%. Now, Rasmussen wasn't doing these polls in, say, 1775, but if they were, I suspect the number would have been higher. Madison famously said, you know, a third of people supported the revolution, a third opposed it, and a third didn't really care that much. Well, that would be almost doubled, right? So that's a troubling note. How long can the country go on if, in fact, most of the country doesn't think it has the consent of the governed? Well, it might go on for a long time. You know, the Austro-Hungarian Empire lasted for a lot longer than anybody thought it could. It just sort of tottered along. It wasn't so good when it fell. Will our country do well? I'm nervous. So that's an argument that we are in extremis. And all sorts of comfortable arrangements entered into after World War II are breaking up all over the world. And a lot of what we think of as our Constitution, in terms of our real way of doing things, our Constitution almost in an English sense, is actually a part of that post-war consensus more than it is something written in the Constitution. And my constitutional law students are always surprised to discover how much of constitutional law is in fact a product of the second half of the 20th century. Before then, the First Amendment hardly did any work. Equal protection didn't do very much work. You can go down the list. A lot of what we think of as 18th century constitutional law is really post-war consensus stuff, and a fair amount of it is not even really Supreme Court case law so much as it is just consensus and how people act. And with that stuff turning over, maybe a lot of the Constitution is going to go anyway. So maybe we don't have any choice about whether we hit the hyperspace button. Maybe the hyperspace button is going to hit us. Well, the Stevenson quote comes from a book which is actually not about the Constitution at all, but it is about computer operating systems. Linux and DOS and all that sort of thing. It's called In the Beginning Was the Command Line. But Stevenson thinks that the Constitution is kind of like an operating system. And actually, so do I. Like when you use your computer, and this varies a little bit depending on the platform you're on, but it kind of fits with all of them. When you use your computer, you've got the operating system, which basically sets the structure for what happens, contains the hooks that the application programs use to get various function calls and do various things, allocates resources among the different programs, keeps the memory up, deals with conflicts and that sort of thing, better or worse, depending. And I think the analogy of the Constitution with an operating system is pretty good. Then we have regular legislation, which is sort of layered on top of it like an application program on your PC or Mac or whatever, that sort of runs on a layer above the operating system. So what does that tell us about constitutional revision, assuming you buy this analogy? Well, that, I think, is sort of a modern way, with a computer analogy, of saying what Justice Marshall was saying in his famous quote that we must remember that it is a constitution that we were expounded, that it was meant to endure for long periods, and it was not to partake of the prolixity of a legal code. You have specific social problems. You want to deal with those, not in the operating system, but in the application software that runs on top. It's easier to change, and if it fails, it's less likely to bring the whole thing crashing down. So just as a matter of sort of good practice and clean architecture and all of that, you want to deal with specific issues, legislative type issues, not in the operating system, but in the applications that run on top. In the ordinary legislation that can be part of the prolixity of a legal code. And when you build the operating system, you want to build it not to address all those little problems, which may seem really important right now, but may not seem so important in 10 or 20 years. You want to build it to set the structure, to allocate the resources, to provide ways of resolving conflicts, and that sort of thing. So what does that have to do with the process of amending the Constitution? Or having a constitutional convention? Well, a few things, I think. First, and this goes back, I think, to Larry Tribe's warnings, which I think were very well put, predicting the result of even modest changes to a complex system is often difficult, and sometimes it's impossible. Anybody who's worked with software knows how true that is, and law is really just software. But a constitutional amendment, a constitutional change, ought, it seems to me, to be aimed mostly at something structural, things that are basic. And there's a temptation not to do that. And the reason is the operating system is more secure. It's less likely to change. If you've got a temporary majority right now on your issue, whether your issue is abortion or guns or whatever it might be, there's a powerful temptation to try to promote that issue up into the operating system, to put it in the Constitution, to lock it down against future change. And I think that's a temptation that's best resisted. And if you look at the history of constitutional amendments since the Constitution was adopted, you find that actually most of them have followed my rules. Most of them are structural reallocations of power. between the states and the federal government and the people. If you look at the Reconstruction Amendments, that's what those did. If you look at the 16th Amendment, they reallocated power between individuals and the federal government. The 19th Amendment reallocates power between men and women, essentially. The 22nd Amendment between the executive and the electorate. And the 28th Amendment between Congress and the electorate, at least a little bit. Others fixed structural problems like getting rid of the dangerous lame duck periods in the 20th Amendment or fixing bugs in the presidential succession scheme in the 25th Amendment. In fact, the only real example I can think of taking a legislative type issue and promoting it to the Constitution was also the biggest disaster in the history of constitutional amendments, and that was prohibition. We took what was essentially a prohibition law and made it a prohibition constitutional amendment. It lasted until it was repealed after a spectacular failure. So what does that say about what we should do? Well, I'm going to give you a few more examples, and then I'm going to have some suggestions for where to go after this, and some lessons we might learn from some other places as well. The examples I'm giving you are not necessarily amendments that I propose. They're things I think are interesting. Are they a good idea? Maybe. I could be talked out of probably any of them. Yeah, probably any of them. But they're, well, I've got a couple of favorites, but they're just illustrative examples. The very first I came up with, actually, this was on the Constitution's bicentennial, and it was my entry in the New Republic's James Madison contest. And it was to rewrite the Ninth Amendment by adding to it at the end the words, "and we really mean it." Now, that was a joke, but it was a serious joke. It came shortly after Robert Bork's inkblot claim, and the point was that, in fact, rights are retained by the people. We have a sea of individual rights with islands of government power in it, not the other way around. And I thought that was a way of stressing, and that's actually a structural point, because it makes precisely a structural point that rights are the default and governmental power is the exception, rather than the other way around. I would add to that the same postscript on the 10th Amendment, which is even more structural. But that's not enough. The Ninth Amendment, actually, when I was in law school, it was literally true that you could walk up to a bunch of other law students and simply say to them the words, "the Ninth Amendment," and they would laugh. You didn't even have to make a Ninth Amendment-based argument. It was just subject for japery. Now it's taken a little more seriously. The Ninth Amendment does a little bit of work. People don't laugh when you mention it anymore. And I guess that's true of the 10th Amendment, too, which used to be a truism and now does a certain amount of work. But depending on the 9th and 10th Amendment to have any real influence on the balance of power between the federal government and individuals is, I think, over-optimistic. So what about Madison's idea, setting ambition against ambition? Why does the 9th Amendment and the 10th Amendment not do very much work? Well, there's actually nobody who benefits institutionally from cutting back on government power. Congress doesn't, and one of the other characteristics of the various amendments that have passed through Congress is they typically enlarge congressional power or national power at the expense of somebody else, usually the states. So Congress is not going to do a great job of controlling its own power. Nobody in the federal government has an incentive to cut back on Congress's power. Courts can strike down Congress's bills if they're unconstitutional, but they don't have any real institutional incentive to do it. So my proposal, and it's not my original idea, the first time I ever saw it was actually from the science fiction Robert Heinlein in his book, The Moon is a Harsh Mistress, but I don't even know if that's the original place. And that is what some people call a House of Repeal. That is a third house of Congress, whose sole power is to repeal bills. Now, exactly how you might want to work this out depends on how many bills you think need repealing. You could, for example, make it wait 5 years or more after a bill passes before it can repeal the bill. You could require a 2/3 vote. You could provide that the original two houses of Congress could just repass the bill right away. And you could even then provide, perhaps, that it could be re-repealed right away. You might get an infinite loop there, but I can't decide if that's good or bad. I don't know. The important point is, in fact, not in these details, even though the details matter when you implement it. The important point is, if you had something like this, there would actually be somebody in the federal government with an incentive to give us less law rather than more. You get elected to the House of Repeal. What do you run for re-election on? What bills you repealed, right? That's all you got. So there's now an institutional incentive to cut back on the growth of federal law. Now, is this a left or a right idea? I don't know. I think it depends. I think the first cut most people would have on it would be to say, well, if it shrinks government, it must be a right-wing idea. But that really depends a lot on what gets repealed, doesn't it? So I'm not so sure. It does seem the case that in our system, things are much more likely to get done if somebody gets something politically out of doing them. So that's one structural idea. Another idea, which I was somewhat misleadingly characterized, no representation without taxation, is not quite that. But we were founded on the notion of no taxation without representation. And we now have a progressive income tax system, which is actually quite progressive. And the result of that is that people who make less money, and that's most people, have less of a stake in controlling federal spending. So, for example, right now, you've probably heard these kind of numbers. The income tax burden of the top 1% of taxpayers exceeds that of the bottom 95%. How do you feel about that as a matter of social policy? Well, that depends on what you think about taxing the rich. But the characteristic of it is that an awful lot of voters have no incentive at all in constraining federal spending, even if it's ultimately going to lead us to bankruptcy. They just don't have skin in the game. Well, now, what you could say is, okay, you can't vote if you don't pay taxes. Now, I'm actually against that for two reasons. Reason number one is it pretty much violates the 24th Amendment, which says you can't deny people the right to vote based on their failure to pay a tax, which seems fairly clear. Now, sure, it's our constitutional convention, right? We can fix everything. We can just repeal the 24th Amendment while we're at it. Why the hell not? But I think actually that captures some pretty good sense. And since I'm a geek and I like to rely on science fiction writers, I'll note that Jerry Pournelle has a fairly realistic future history in which citizens are actually divided between citizens who are people who are on the dole and taxpayers who have a lot higher status. And it's not a very attractive future history. I don't think that's a world we want to live in. I don't think we want to live in a world where you become a second-class citizen because you don't make a lot of money. What I do think, though, is that everybody ought to pay some tax. And not only should everybody pay some tax, and it doesn't necessarily have to be a lot, it ought to go up when the federal government spends more, and it ought to go down when the federal government spends less. It ought to be tied year to year to that. And if you do that, people will care about something that right now a lot of people don't care about that much. They may decide they want the government to spend more money anyway, but at least they'll think about it. And as evidence that this works, when you say people don't pay income taxes, the response you frequently get is, well, what about payroll taxes? And of course, a lot more people pay payroll taxes, and they're pretty regressive. Not everybody does. If you don't have a job or if you work under the table, as increasingly large numbers of people do, you don't pay payroll taxes. But still, what do we have right now in the payroll tax department? A payroll tax cut. Why do we have a payroll tax cut? Because a lot of people pay payroll taxes, and they care. Now, that doesn't help things as it is now, because there's no connection between the payroll tax cut and the spending. We paper over the difference with debt, which is not so great. So maybe that brings us to question the next, a balanced budget amendment. That would solve that problem, right? Well, possibly. I'm sort of skeptical about the balanced budget amendment, and the reason is not because I don't think it's a good idea to have balanced budgets. I think generally it is. I think certainly events in Europe as well as events at home suggest that the framers were right when they thought that democracies generally had a tendency to spend themselves into bankruptcy. That was a structural flaw in democracies in general and needed to be counteracted. And that seems to be the case here. We've seen various balanced budget proposals out of Congress. Most of them are actually fairly weak tea when you read the details. For example, there's not a balanced budget requirement if we're in an armed conflict. How many armed conflicts are we in right now? At least 8, somebody says. I was thinking 7, but I really actually have to stop and sit down and sometimes do a Google search. Right, I mean, there's so many, and then, right, there may be some we don't know about, too. So that seems like a pretty big loophole. I'd be okay with it if it said congressionally declared war, but maybe, but they don't like that. I guess you go the full Ron Paul and just say that Article 1, Section 10's provision against the states making anything but gold and silver a tender in the payment of debt should be extended to the federal government. That seems like kind of strong tea to me, though some people would disagree. But it certainly seems that we need some kind of structural control of spending, and I will tell you a place to look, echoing Sandy Levinson, and that is state constitutions. One of the things you see when you look at state constitutions is they spend what, compared to the federal constitution, seems like an incredible amount of time on sort of picayune, workaday questions like where the money comes from and where the money goes. You know, they're just full of that. The federal constitution glosses it over in a couple of sentences and moves on. Next, letters of marque and reprisal. But state constitutions go in great detail. How much money you can borrow, when you can borrow, what you can spend money on, how much you can tax people, sometimes with a percentage rate specified right in the Constitution, all kinds of, and they do that because states can't print their own money. Maybe there is, it's because of Article 1, Section 10 and all. And also maybe because traditionally we've thought of state legislators as being sort of more venal than federal legislators. This may be incorrect. But I think we've thought that, and I think state voters have felt more comfortable reining in their state legislators than the electorate at large has felt was necessary for federal legislators. Well, I give you our $15 trillion debt or whatever as evidence that perhaps that's incorrect. Now, another thing people want is turnover. And you hear a lot of talk about term limits. Now, I'm very lukewarm on term limits as well. That is a structural change, and the idea is that when people get into the political class, they become entrenched there. They become, in fact, a faction all their own, which exists regardless of party, which I think is true. Republicans and Democrats in Washington and in political office have far more in common with each other than they have with the people back home, and they tend to pretty much scratch each other's back and to support proposals that tend to enrich the political class at the expense of everybody else. That's what they do. I won't go so far as Albert J. Nock and say think of the state as a criminal gang and you will not go far wrong. But on the other hand, it was Will Rogers who said America has no native criminal class except for Congress. Perhaps. So the theory is by turning them over, you bring in fresh blood, and basically by the time people start to get corrupted, it's time to boot them out again. I'm lukewarm on that. In my Is Democracy Like Sex article, what I posited was, there's this argument among evolutionary biologists about why we have sex, because it turns out it's a lot of trouble. And if you can just reproduce, by fission or budding or something like that, you really save a lot of effort. So why do you have sex? And the answer seems to be that when you have sex, you mix your genes up, you produce a new organism that's not identical to the parents, whereas if you reproduce by fission or budding, you have a whole bunch of clones out there. That means any parasite or disease that infects one of them infects them all. They're all just as vulnerable to it. You mix things up with sex, you get a much more diverse population, and the diversity protects it. So my theory was that Democratic turnover in office has the same effect. It's semi-random. It brings in different groups of people and breaks up the too close connections between special interests and legislators and executive branch officials and so on. I still think that's true, but I have to say I wrote that article in 1995, and things seem to have gotten somewhat worse, and I've become a little more concerned that the role of gerrymandering may limit the effect of this more than I originally thought. Another proposal, taking another leaf from the Book of State Constitutions, is the so-called Truth in Legislation Amendment. That's not my proposal. That's actually from Brannon Denning and Brooke Smith. But the Truth in Legislation Amendment would basically require the kind of single subject rule that a lot of states have for laws. So you have a caption for your bill. It says what the bill does. If you do anything else that's not in the caption, it's void. Now, we have that in Tennessee. Laws tend to be short. It makes it impossible to pass these gigantic omnibus bills that are full of payoffs to special interests. You can't figure out what's there until after they pass, and so on. It requires stuff to be relatively straightforward and clear. Things that would be done in a 9,000-page bill now would have to be done instead in 190-page bills or whatever, and it makes it a lot more difficult. I think that's pretty good. And here's the one. I was saying I had, of all these proposals, I could be talked out of any of them. Here's the one where I'm not so sure. And that is a requirement that once you are elected to the United States Senate, you are forever ineligible to the office of President of the United States. Because here's my thinking. Senators hardly ever get elected president anyway. It's pretty unusual. But of the 100 people serving in the United States Senate at any given moment, probably at least 93 of them think they've got a shot. And everything they do in the Senate is colored by that belief that they've got a shot. So if we just take that away, we do two things. First, if you're a senator, you might as well be the best senator you can be because you've topped out. And second, you don't attract to the Senate the people who see it as a stepping stone to perhaps being president. And it seems to me that's a benefit all the way around. So that's one I'm not so sure. I could be talked out of it in principle, but you'd have to work hard on that one. Those are some thoughts, and I don't think that they're necessarily the right ideas, but all of them are structural ideas designed to address structural problems, as opposed to, say, was it the Human Life Amendment that would ban abortion, or a lot of other specific hot-button amendments that, had we had a constitutional convention 20 or 30 years ago, would have been the main thing we talked about. And there's another lesson in that, which is perhaps a lesson of humility. If we had had a constitutional convention 30 years ago, I am pretty much certain we would have spent most of our time talking about abortion. Well, I mean, that's still an issue people care about, but that was not, in retrospect, the thing we should have been worrying about the most in 1981. And it's very possible that whatever hot-button issues we have now that we might want to talk about in a constitutional convention won't be the things 30 years from now we'll think we should have talked about. So some humility really plays. As we look at this stuff, I've given some state constitutional examples, and one thing where Sandy Levinson and I are in total agreement is that state constitutional law doesn't get enough attention. I teach a seminar in state constitutional law, and I found it a real eye-opener. I went to law school at Yale. We barely even studied the U.S. Constitution. Select parts got a lot of attention. I actually had Goldberg against Kelly in Admiralty class, and no, I am not making that up. They didn't offer commercial law the whole time I was there, though. But state constitutional law is actually really useful, and it is a vast reservoir of ideas that have been tried. The match isn't perfect. States aren't the federal government, but they're the closest thing we got, and you can really learn a lot from that. Finally, I can be talked into having a constitutional convention, or I can be talked out of it. Arguments in favor of it are, well, one argument in favor of it is, if we have a constitutional convention sometime in the next few years, all of you will be able to claim that you were there when it really started. And thanks in particular to the large number of Harvard alumni in the press and among historians, you can guarantee they'll say that. So that's pretty cool. But there's another argument, and that is that the function of constitutional conventions to date has been kind of like a fleet in being. It's sort of threatened the political class and forced them to clean up their acts and something for fear of what would come next. To them, too, it's like the hyperspace button, and they're not so sure they want you to push it. And there is an advantage to that. Some political operative once said, I think it was Clay Whitehead, the value of the sword of Damocles is that it hangs, not that it falls. And it may be that that's the chief value of a constitutional convention, the threat of one, that it hangs, not that it falls. And we may, in fact, achieve victory through incrementalism. Well, I much prefer to hear you talk than to hear me talk, so I'm going to stop with one final question, because I don't see this as entirely unlikely. What if the requisite number of states, maybe even a couple of extras just to make it more fun, sent a clean call for a constitutional convention to Congress, and Congress did nothing? What would that mean? I can think of a couple of things it might mean. It might not mean anything. It might just come to nothing, as all the calls so far have. It might also be grounds for revolution. When I mentioned this to Larry Lessig last night, he said, well, that would be revolution. Would it be? I mean, in a sense, if a requisite number of states call for a constitutional convention and Congress refuses to act, is that an announcement that the current system is illegitimate? That it's no longer functioning under the Constitution, that it's no longer checked by the Constitution? And if so, do you owe it loyalty? What would a citizen who reverences the Constitution and their role as a citizen do in that situation? I don't have an answer to that either. I'm not telling you to go straight down to the Capitol with pitchforks, but it seems to me it would be an extremely important and transformational event if it happened. And I think one of the things you want to think about in deciding whether to call a convention or not is how you would deal with that if it happened. I think we're ready to take questions now.